Welcome all. Today we are going to discuss about Financial Action Task Force circular issued by RBI. Now, this Financial Action Task Force periodically identifies jurisdiction with weak measures to combat money laundering and terrorist financing and publish two lists. These two lists published by RBI are list of high-risk jurisdiction and jurisdiction under increased monitoring. A jurisdiction whose name appears in the aforesaid two list shall be referred to as FATF non-compliant jurisdiction. Now, today we have requested Mr. Raj Dev Singh to guide us on these particular circular as well as RBI regulations in relation to these circulars. So let's welcome Mr. Raj Dev. Mr. Raj Dev would like to understand what is this FATF.
Sure. Abhijeet, thank you for this opportunity, first of all, wherein to discuss about this important topic. And there are certain ambiguities that today we are just going to clear it out as well. And there are some ways out as well that how to deal in such kind of scenario wherein such circulation is there in place. So as you asked the question about what exactly it means, then the Financial Action Task Force, in short, we call it FATF. That's an intergovernmental body which is established in 1989 in Paris, and that was established by G7 countries and by the ministers of its member jurisdiction. It acts as a watchdog for anti-money laundering and financing of terrorism for member jurisdiction all over the world. Present the jurisdiction which are not compliant with the regulation of FATF and on the blacklist, these are like Iran and North Korea. Some gray list includes Barbados and Botswana, Cambodia, Ghana, and then Jamaica, Mauritius, Myanmar, Pakistan, Panama. So, and then Yemen and Zimbabwe is also there. So the listing serves as a signal to the financial and banking system about increased risk in transactions with the listed company, and that may negatively impact the economy of such countries. So this is what FATF means. Yeah.
And, what is the requirement of this particular circular? And what is this circular? Is it about investment in NBFCs by this non-compliant jurisdiction?
Okay. So see, the problem is restriction come in a wake of the increased scrutiny of NBFCs post the recent collapse of certain entities and with a view to restricting money laundering specifically. So RBI had started closely examining these all investment, specifically from Mauritius also last year itself, and they had written multiple application by various NBFCs due to their connection with the Mauritius. So this was, I can't say that, okay, this is because of Mauritius, but yes, because it had happened in Feb 2020 and due to certain systematic deficiencies. So that's how this also came into the picture. And the RBI then issued a circular on 12th of February, I think, 2021, to impose restriction on investment in NBFCs and by investors from FATF, non-compliant jurisdiction. So the restrictions are applicable with the immediate effect, which is from 12th of February 2021 onwards. And the jurisdiction on the FATF blacklist include, as I said, like Iran and Korea is there, and there are certain countries that I already informed about the gray list. So in the new investors from or through FATF non-compliant jurisdiction will be prohibited from directly or indirectly acquiring significant influence in the existing NBFC, as well as companies seeking certification of registration, like COR. So when you talk about the term significant influence is quite important over here, and which is having more than, I mean, they talk about 20% of the actual and potential voting power. So this circular requires considering the aggregate of the actual and potential voting power. Potential voting power includes rights on the account of instrument that are convertible into equity, other instrument with contingent voting rights, or contractual arrangement, contingent voting rights, and these all things are there. So the restriction under the circular will probably is not going to apply to the existing investment, that is for sure, in NBFC from the FATF non-compliant jurisdiction.
Okay.
And this is all actually that we can talk about this. Yeah.
Okay. Okay. And is this circular applicable to old investors as well as new investors equally, or there is some difference?
No, there is a difference. So what is the difference? So there is a bifurcation between the new investors and old investors. So new investors from or through FATF non-compliant jurisdiction will be prohibited from directly or indirectly acquiring a significant influence. Again, that word is quite important in the existing investees as well as the companies seeking COR. So this term again, significant influence is defined as having more than 20% of the actual and potential voting power. So this consequently, prohibits new investors from FATF non-compliant jurisdiction from acquiring more than 20% of the voting right in NBFC. Now, old investors, the restriction under this circular will not apply to existing investment in the NBFC from FATF non-compliant. They have also been permitted to bring in additional investment to support their continuity of business in India. But such additional investment should be in accordance with the extent regulation.
Okay.
Yeah.
Can you tell us more about this definition of significant influence, as well as how you can calculate this significant influence?
Yes. So there is no Abhijeet rocket science into this. I mean, that's quite simple, because about our Indian accounting standard, specifically 28 number. So significant influence is the power to participate in the financial and operating policy decisions of the investee, but it is not control or joint control of those policies. So an entity where they may own share warrants, share call options, or debt or equity instruments that are convertible into ordinary share, or other similar kind of instruments that have the potential. So to give the entity additional voting power, or to reduce another party's voting power over the financial and operating policies of another country. So that is called potential voting right. So an entity loses significant influence over an investee when it loses the power to participate in the financial and operating policy decision of that investee. So the loss of a significant influence can occur with or without a change in the absolute or relative ownership levels. This is the best way that we can define, and it can be calculated in that manner.
Okay. And under this circular, how much percentage of shareholding this companies have, right? And what would be the impact of RBI circular on acquisition of NBFCs on this?
Okay, right. So see, the new investors from or through non-compliant FATF jurisdiction, whether in existing NBFCs or in companies seeking certificate of registration, they should not be allowed to directly or indirectly acquire significant influence in the investee as defined in the applicable AS 28, that is in the accounting standard. So if I say it in another word, then fresh investors directly or indirectly from such jurisdiction in aggregate should be less than threshold of 20% of the voting power of the NBFC. Potential voting power could arise from instruments that are convertible into equity, other instruments with contingent voting rights, contractual arrangement, and so in such cases, it should be ensured that new investment from FATF non-compliant jurisdiction are less than both. Means the first is 20% of the existing voting right, and the second is 20% of the existing and potential voting powers, assuming those potential voting rights have materialized. I mean, if we talk about RBI, then they have set the norms as well, which are required to be followed by the NBFCs in case of acquisition or to take over. So these are 4 or 5. So like one is takeover or acquisition of control of an NBFC requires prior approval also of RBI, whether there is a change in the management or not, and it has to be in the writing as well. And then, however, no RBI approval is required in case there is a change in the shareholding for more than 25% for the reason of buyback or reduction in the share capital. It's still but they are competent. Authority should have, the authority should have approved this reduction or buyback, and the same is, but the same is, however, required to be RBI not later than like 30 days from its occurrence. And in case of any change in the management of the company, which would result in more than 30% director, then prior written approval is required. And the last is change in the direction of the company requires prior public notice, at least 30 days prior to the announcement, if there is any change.
So basically, we are saying that if directors are changed more than 30% in these NBFCs, right? If the investment from this FATF non-compliant jurisdiction goes beyond 25%, then in all the cases you require approval from RBI.
Yes.
Right?
Yeah.
Okay. And what about other shareholders if it is 25% by non-FATF compliant company, and other shareholders are also there, which are from Indian origin, Indian companies who actually invested in the state of NBFC. So is permission from RBI still required?
No, see, what we have to see, Abhijeet, is that in case of any change in the management of the company, which would result in more than 30% director, then only prior written approval is required, right? See, there will be no RBI approval in case there is a change in the shareholding for more than 25% of the reason of buyback, or maybe
Okay. And are there other modes available through which NBFCs can raise funds?
Yes. There are many ways to do that. For example, NBFC can now raise this external commercial borrowing, that in short we call it ECB, with a minimum average maturity period, which is called MAMP also, of 10 years for working capital purposes and general corporate purposes. ECB borrowings with MAMP of 10 years for working capital purpose and general corporate purposes as well. And apart from the external commercial borrowing, there are many ways of doing that. So for example, long-term loans at lower interest is there, and then foreign direct investment options are there. So wherein there are many kind of options like underwriting, portfolio, stock broking, and venture capital, and leasing and finance as such. So the government has also introduced new FDI norms for NBFCs to accelerate non-banking financial sector. So the rapid increase of foreign direct investment (FDI) will be highly beneficial for the NBFC business model due to easier and you can say faster sanction of funds at reasonable interest rate. Apart from this, we can issue commercial paper for small loans. So these are like common scenarios which NBFCs are already doing that, issuing bonds and then securitization of loans. So these all like this, there are many kind of options that are available right now.
Okay. And how legal firms can help these companies to raise capital?
Okay. So see, there are, as we know, there are a significant legal restriction on how you can solicit debtors, and NBFC probably may seek help of from the law firm to understand the increasingly complex and overlapping regulation and guidelines. So law firm can help NBFC by negotiating on terms favorable for the companies during any transaction with investors, and cautioning the company on any unfavorable terms sought by investor. So legal firms can advise and assist the companies with a legal service that enables them to compete in the world, in the modern economy, which enables them to compete compete with them. So apart from this, law firms can also help them to adapt best global practices and technologies in local condition, and advising them about legal aspect involved in the modern markets in order to keep the company in pace with the dynamic competitive environments. Even LA took a stern view on Mauritius post its grey listing, which means it's a FATF non-compliant country. SEBI had allowed category 1 FPIs from Mauritius to trade on Indian stock exchange. So besides pooling in institutional money, category 1 funds can issue a subscribe to a participatory notes as well. So these are these are high risk jurisdictions we can talk about. So I would also like to add, Abhijeet, about this, which can be considered not under you can say under significant influence as per the circular also, that according to Indian accounting standards, any entity may own share warrants, share call options, debt equity, and all these things are there. But apart from this, I think companies can develop strategic steps towards identifying funding from FATF non-compliant jurisdiction, and it can set up strict compliance to avoid investment from the non-compliant jurisdiction. Further, these legal firms can also help them to do a due diligence for such companies to ensure that they comply everything as per the law. See, Abhijeet, whole in whole, the idea is of this circulation is to stop the stop something which is happening in a wrong manner. So the intent of the legislature is very clear from this aspect. So if you're doing something wrong, then one should stop this. However, if suppose you're not doing something which is in favor of law and as per the law, then it's quite legal. So it can always be challenged by way of writ as well. If suppose we see like there are some restriction and there are some unnecessary circulation that has been passed by RBI, then it can also challenge as well. If the intent is right, then everything is right. If the intent is wrong, then obviously there can't be anything that we even lawyers can do.
Right.
So this is all that I can probably advise. Yeah.
So thank you very much, Mr. Raj Dev, for joining us and sharing knowledge with all. Thank you very much.
Sure. Thank you, Abhijeet. Thank you.
Thank you.
Thank you. Bye-bye. Take care.
Bye. Bye. Take care.
Bye-bye.